Hello, today we're going to be talking about what happened if the employment is terminated during the green card process. And we're dividing this to 3 different distinct videos. And this is the one out of the 3 videos, and it's going to focus on the termination of your employment during the labor certification part of the green card process. I'm Sam Shihab.
I'm Brian Burke.
And Brian?
Yeah, so Sam, you know, we're talking about the 3 overall steps of the green card process. When I'm talking about step 1, the PERM Labor Certification, there's all sorts of sub-steps in there. So I figure what we do is we go through, we talk about all those sort of sub-steps in the process, and we'll talk about what the impact is if your employment is terminated and thereby your labor certification process is terminated. So Sam, let's talk about a big, wide bit of it. Any time before the PERM is filed, you're waiting on a prevailing wage, you're waiting on recruitment, or, maybe they're just getting close to filing, but didn't quite make it there. What happens if the employer terminates a position and thereby terminates the employee and thereby terminates the labor certification process?
So in that recruitment stage, or the pre-filing stage of the labor certification, which there's a lot of activities that happen before you file that labor certification. If the employment is terminated and the labor certification is not pursued further by the employer, there are really no rights that attaches to the beneficiary, unfortunately. So there's no H-1B beyond 6 years, for example. There is no spouse EAD, and there's no priority date that is attaches to the process, and therefore there's no benefit as the employee move on to the next employer.
Okay, so let's move the process forward. Let's say, you get that PERM filed. The employer submits that PERM electronically to the Department of Labor, and the Department of Labor is in process. They're looking at it. What happens then if the employer says your job is done, or terminating your position, or terminating your labor certification process?
So if the PERM is pending and the employment is terminated and the labor certification is withdrawn or terminated, just like I answered before, no benefits, no H-1B beyond 6 years, no spouse EAD, and no priority date that attaches to the employee as that employee move on to the next employment and their next journey in the green card process.
Okay. Well, how about then, Sam? I'm going to move it a little bit further. Let's say you get that PERM approved. The PERM is in your hands. There's still stuff to do with it. I-140 stage is next, but the PERM is approved by the Department of Labor. Any benefits that attach there?
Unfortunately, Brian, to disappoint you, there are no benefits, no H-1B beyond 6 years, no spouse EAD, no priority date. And with all those 3 stages, as the employee moves to this new employer, to a new employer, there is nothing that you can take with you, and the new employer must file a brand new labor certification from the very beginning.
Yeah, so it's worth bringing up. There's sort of an outside scenario where the employer terminates a position and the labor certification is left active. There's some scenarios under which you might be able to extend your H-1B beyond 6 years with it, even though you've left the company, right?
You're right on. So what we're talking about here is a narrow scenario in which, let's say, the employer terminates the employment with a future desire to rehire this employee, so they keep the labor certification continuing.
Yeah.
And that labor certification that is either active, in process, or approved but not expiring, and the H-1B expires, the 6-year H-1B expires, then the employee can extend beyond 6 years if 1 year has passed since that filing of the labor certification application and it's still pending or it's still active. So in that narrow scenario, there is a benefit, and it's worth that you discuss this with a qualified attorney to understand whether it applies to you. But this is really a narrow exception here.
So bottom line, if the process is truly terminated, no benefits. If maybe it's being kept open, there's an outside chance you might be able to use it to extend your H-1B.
Yes, most of the benefits comes in the I-140 stage and beyond, and that's going to be the subject to video number 2, part 2, or part 3. So tune in to the next video to learn more about termination of employment during the green card process.